Should I share the content? Presentation share the.
Very, that would be better.
Allow me to share.
Yes, sir. I've allowed you.
Done.
Done, Rahul.
Okay. Is it visible?
Yes, it is.
मुझे ना एक वो next time ना you give me your logos and all that as well. ठीक है? So I can place it properly.
Add those. Sure.
Okay, let me just keep it like this. So, आयरा कौन सी क्लास में है अभी?
Oh, she's in preschool right now. Very small.
Okay. Do we have visitors? Yeah, we have some participants.
I think. Hi, Jabba. How are you? We have one round right now and more coming on YouTube.
Sure, sure, sure.
Hi, ma'am. I'm traveling actually, so I thought I cannot join, but anyhow I have joined. I'm fine, ma'am. Java here.
Okay. Okay. Thanks a lot for joining in. We'll just wait for a
Yeah,
few minutes and then we'll start.
sure, sure.
Rahul, maybe we can start. Um,
Can? Okay.
maybe we can start this session.
Sure.
I have a few at the YouTube also, and maybe
Okay.
people will keep in joining.
Sure. So, you want to begin
I'll
with something or? Yeah.
Yes, I'm going to introduce you. So thank you everyone for joining me. Um, Good evening, good morning, wherever you are from. So hello to all of you. Thank you so much for joining in for this essential topic. So while I was looking for a speaker to start these sessions on this series on IP financing, I thought there are three key requirements. One, the speaker should be aware of what IP financing is essentially, but then he or she should have worked with startups, knows the pain point, and maybe has also created his or her own startup. And the person who came to my mind was Rahul, who has been in this field for last 15 years. He has not only helped innovators but also a lot of startups, and he runs his own startup. So he has all, he met all the checkpoints. And a fun fact that, I have a daughter whose name is Ira. She calls herself as Ira, but it's actually Ira, and his company name also has that name. So it's just a coincidence, but he is running a company called as Om Ira, and my daughter's name is Ira, so this is connection. So I thought of reaching out, and he has been kind enough to accept my invitation and come and speak upon IP financing. In case you miss out any portion of this talk, don't worry, you are covered. We have it there. It will be available on Dhwani's YouTube channel. Dhwani is an vertical of Innoberry. Innoberry takes care of IP management and technology transfer, and also helps young professionals in deciding if IP is the career for them. So without taking much time, I'll now request Rahul to come on stage and, talk about IP financing. Rahul,
Thank you.
over to
Thank
you.
you. Thank you, Pooja. Thank you for a glowing introduction, as well as the connection with Nomira and Ira, your daughter. So the topic today is kind of interesting. It touches areas of law, finance, corporate law, IP law, and there are more and more innovative models that are coming up and will continue to come up. So I'll discuss some basic ideas and some very interesting models that have happened in the past and continue to be evolved for IP, and what are the challenges in financing IP, or say getting money or turning your IP into capital. What are the challenges in different countries and different parts of the world? I'll cover those basics around that. So basically, IP, as IP financing, the term is very self-explanatory. Basically, you want to convert your intellectual property into a real cash flow asset. Okay. When I say cash flow asset, means you have patents, you have trademark, they're lying there. But how do you, because you make a home, you rent it out, you have a cash flow. You have a car, you rent it out, you have a cash flow. So what do you do when you have an intellectual property asset like your trademark or patents? One way is definitely where you enforce your patents against your competitor. That is one way how IP rights help you so-called capitalize, right? But how do you generate a cash flow out of it? What are the different models of actively financing or creating financial opportunities from your IP? That is what we'll discuss. So one way of IP financing, you can say, creating cash flows from IP is through enforcement and litigation. And that is a very separate topic. Okay. Here we are talking about an active method of raising money, of getting cash flows in regularly, raising debt, etc., using your intellectual property assets. And sometimes it works. In some models, it works similarly, like in patents, trademarks, and copyright. Sometimes it is good. Sometimes a certain model is good only for copyright. So we'll cover those aspects as well. Now, the way you can convert your IP rights into cash flow quickly is obviously by selling your IP rights or by licensing them. You can use your IP as a collateral to secure loans. Now, this statement is loaded, I would say. When you say you can use your IP as collateral to secure loans, it means some banks might allow, some banks might not allow. Some institutions might allow, some institutions might not allow. Private institutions, private investment funds, they may give you debt against the intellectual property, right? But public sector banks, they may not give it to you. So it's a lot of complex maze that one has to go through to really realize IP into active cash flow. Okay. And so basically, and this approach of IP financing is ideally said to be good for companies with good portfolio, because one or two patents, if you have one patent in your portfolio or two patents, right, with no past track record of having struck gold with inventions, right, it is difficult to secure financing. It is as good as if you are not a co-founder earlier in a startup or in a company, and then you're a first time founder of a company, it's difficult to raise money. It's the similar analogy like that. Okay, so we cover some basic methods of IP financing that are available. Now, these are some of the methods of IP financing where IP is used as a leverage to raise money or to generate cash flows. One is royalty-based financing, a very popular model used by artists, usually used in copyrights. Securitization and tokenization. This is with Web3, with the blockchain. You must have heard of non-fungible tokens and all. So that is also happening. That is another way of creating financing opportunities. Securitization is when you convert your patent or IP into a stock. How do you do it? That is another way. IP asset and return generation, basically by licensing your IPs, mortgaging your IPs, how to generate cash flow. Patent-backed securities. Again, this is kind of securitization, and tokenization in the point 2 refers to Web3 based. This patent-backed securities is more corporate law oriented. When you structure your companies to create opportunity or to raise money based on your patents. Then IP-based lending. So you raise money or you debt in your company by mortgaging your intellectual property assets. There are some popular cases which we will discuss. Then merger and acquisition opportunities. Sometimes a bigger company acquires a smaller company purely for their IP and nothing else. They don't recognize any other asset. Case in point, like Google acquired Motorola only for their IP, 10,000 patents portfolio. Okay. Then Bowie bonds. This Bowie bonds is one of the case studies. It covers some different aspects of it as we go along. Okay. Now, Bowie bonds is a case study on royalty-based financing. I'll tell you how it works. Now, David Bowie was a very famous singer, right? Now, what happens is for artists, the copyright is usually valid for 60 years after their death in India. In US, it's I think 75 years. In in UK, it is 75 years. In US, it's 80 years. Different countries have different rights. So after the artist has died, the artist's heir to the artist or their estate, they continue to earn money through the royalties that they plan with their producers or labels. Okay, so estate is able to earn money. So whenever somebody wants to use their song or music, they pay a licensing fees even after their death. Now, David Bowie had an idea. So David Bowie was working with this manager, with this old label, and he's doing very well. And now he wanted to take back his catalog, his music catalog. He wanted it back. But he knew that based on his popularity, his coming 7-10 years, right, will be much more profit churning. Okay. So he went to an investment bank, spoke with them, created what is called as IP bonds, and which are now popularly known as Bowie bonds. Basically, he backed his future royalties of next 10 years. He made a bond next 10 years and said, okay, I'll pay 8% return on your investment for next 10 years because these are my projected royalties in coming 10 years. And then he was able to raise millions of dollars. Using that $1 million, he was able to buy back his catalog from his company. And then because he bought back the catalog from his company, from his label, now he owned it. So his royalties also increased. So he was able to pay it back as well. So this was one of the most innovative model of IP financing, where especially useful in cases of artists, musicians, fashion designers, painters, or something like that, right? So artists ke liye, for the artists, it's the most used tool. It could have been most used tool, but it never really picked up because 90s was marred by piracy in music and artwork. But then this laid open a lot of avenues for different kind of experiments that have happened in IP-based financing in different parts of the world. Okay, so again, once again, just to summarize, so you basically tell investors, hey, this is my 10 years royalty cash flow. Okay, this is my streaming. I'm going to do these many shows, these many stadiums. I'm going to sell out. So these are my potential income in next 10 years. Okay, and now I'm a popular artist. So I'll be doing merchandising, branding, advertisement. So all this income, I want you guys to invest in me so that I can buy a catalog. Okay, and from these royalties, I'll pay you 8% return, which was much higher than in any debt market at that time, when David Bowie came with these bonds. And he was quite successful in monopolizing all his musical catalogs under his own name. So this is a sort of royalty-based financing. The future royalty potential is used to raise money in the present. Okay, that is one method. Now, how do you value this? Now, the problem is not the problem. The challenge is in two parts basically. One is the valuation. How do you value the future 10 years royalties, for example? How much it is going to be? How much is the projection to be right? Another is structuring the agreement or the contract itself. Okay, how many times will these structures or securities will be issued? Will they be issued as units, for example? How much to price as a single unit, and how the price of one unit goes up, for example. So the structuring and the valuation are the two complicated parts of it, very much left to the lawyers and corporate lawyers and IP lawyers together, where they can structure the agreements and the asset that is being laid out in terms of units as well. So basically, if I am subscribing to David Bowie bonds, right, I pay in say $1 million. So do I get units, or do I get the share percentage in the bonds? What do I get? So that kind of structuring is being referred to here. Okay. Now another is when you create IP assets, right, and then you generate cash flows directly out of it. Okay. Now in that, the main tool is patent-backed securities. This is one of the most upcoming methods of generating cash flows. Now you will notice that a lot of time, what happens, you will see that big companies, especially one with large portfolios, or on the path to making large portfolios, what they do is they hold their IP in a different entity. Okay, they create a different entity, special purpose vehicle (SPV) or a special purpose entity (SPE) is created only to hold the IP rights. Okay, it only holds the IP rights, and then it licenses it to the main company that is producing the or that is making the products or delivering the service. Okay, and it is being used in startups very well. I give you one example, and there's one very popular startup in India. It's not startup anymore, I would say, but they obviously 5-6 years ago they were startup. So they started out. They have a portfolio of about 50 patents, and then some other partner, some bigger company with big cash flows and all, they approached them. They liked their technology. They wanted to do a joint venture. So what we did, we structured their joint venture agreement where we backed their equity, that the equity of this our client, of our startup, in the joint venture was decided on the basis of the value that their patent will lend into the overall company. So this is a sort of patent-backed security. So the startup doesn't invest any money. Okay, they are able to enter a joint venture with a bigger company purely based on their technology. Okay, and they take 40% stake in it. If they wanted another 10%, then they had to pay some cash, which they didn't agree. They said, we'll just give you the technology. So that is an active method being pursued by several companies in creating immediate cash flow opportunities. Okay, and it's not just 40% on the capital, because this you have formed the company. But what happens, because you're not selling your IP rights to this joint venture, you're licensing it, number one. Because you're licensing it in future also, whenever this joint venture company makes a earning, so they will also have some royalty going back to the parent company, our client, as well, because there's a royalty element attached to it. So it's a complex model. You see, royalty-based financing of IP, as well as a patent-backed security, both being executed together. So you form these structures and agreements through detailed negotiations, right? So this is what is called as patent-backed securities. By security, we mean stock or equity or any corporate debt, basically, can also be created around it. Okay. Now, another popular approach on IP financing is lending. Recently, I read news that in UK, NatWest Bank issued a loan or debt of, I think £5 million or £10 million by amortizing the IP assets of a software company. Okay, when I say IP assets, doesn't necessarily mean only patents. It could be copyright, trademark, everything. Okay, so in UK recently there was a case where the bank loaned this money to a very young company, I think 2 years old only, against their IP. So IP-based lending has also picked up in India. A very popular case in India was by Kingfisher. So Kingfisher loaned their trademark to a consortia of bank for about I think $100 million, $150 million, $150 million or so in current currency rates. Okay, so IP-based lending has happened in India. Okay, and in other parts of the world as well. And it is very common in US where IP valuation is very well determined. There's a lot of benchmark available across different technologies on the valuation of IP through court judgments, for example, because there is a lot of infringement and court activity in US where a lot of damages are given out in different technology areas, and the courts have gone in detail in figuring out valuation mechanisms. So there is a very good market in US, especially where the valuation principles can be easily justified and established. Okay. Secondly, for IP based lending to work, there needs to be a very active buying entity as well, a potentially buying entity. You know, basically there should be a bigger entity in the corporate ecosystem of India. For example, if I'm an AR/VR, I am working out AR/VR patents. I have 50 patents on augmented reality and virtual reality related technologies, for example. But in India, if there is no big player in AR/VR space, right? So the banks and other investors will look at it suspiciously, because if they default on the loan, then who would they sell this IP to? Who's going to buy this IP, basically, right? US allows that ecosystem very favorably. It has a lot of players willing to buy IP. They understand the value of IP. So different markets at different levels of maturity are valuing this IP-based lending in a very different manner. Okay. Then M&A, mergers and acquisition, as I said, is a very active way of IP financing. Right now, at Omira also, we are negotiating a transaction on behalf of some bunch of investors who are buying out a very big company in sensors based out of Austria. We are conducting a thorough IP due diligence of around 1,500 patents. The whole transaction of this, the company is being bought out for lots of millions of dollars. I cannot disclose the figure, but the whole transaction is centered around their IP assets. Okay, so we have to make sure that out of their 800,000 patents, at least 60 to 70% of the patents are valid, are in good hands, are covering the good part of their technology, and are not suspect to litigation or revocation. So an IP due diligence goes in a big way. Okay, so in this entire merger and acquisition activity of this very big sensors company is happening purely because of their very unique position in that market domain in terms of holding intellectual property. Okay, and the valuation is basically then arrived at so because the company has been generating revenues, so there is a historical benchmark to value the IP, or you can say to value the company. So basically you will see the company's revenue is being used as a proxy for calculating the value of the IP. But company's acquisition will be completely done only when the IP's health of IP is properly justified. Sometimes, if the IP is not as good as being projected, or the portfolio is not as good as projected, they negotiate. The buyer companies, the buyer investors, they negotiate hard on the investment acquisition price as well. They say if the only 20-30 patents are good enough, then value will come down drastically. Even then, revenue even might not matter, because they are valuing IP on the higher side in the entire asset class of that company. Okay. Now coming to IP-based financing, it works as I said. If we have to summarize all that we are doing right now, will be that IP is definitely being used as a collateral one way or the other. IP is being used as a collateral one way or the other. for lending, for raising money through equity, to corporate debt, to convertible notes, to convertible debentures, etc., etc. Okay, and then sometimes through royalties, sometimes through mortgaging as well. And then IP as collateral. Yeah, I think we covered this. I have to. Okay, now how startups, now coming to more, let's come to more, let's step away from more artist oriented approach. Okay, how startups or how companies can use intellectual property to raise capital. Okay, and how they can, what is being done currently also. I will tell you different models that are being explored in different parts of the world where startups only bring IP to the table. It could be patents plus copyright, because if you are in high impact AI, machine learning, robotics, software driven company, then a robotics devices driven company, then you have patents and copyright together and a lot of technical know-how, which is an unregistered IP. Okay, there's a lot of contracts also become part of your IP. Okay, so what do you do in that? So many startups, many investment funds have come up now who look into IP. Okay, and they give you, without valuing your company, purely based on the IP, they're okay to give you a convertible debt. Now the convertible debt is when they convert the debt into equity upon realizing of a certain milestone. So it is a sort of IP financing hidden through a traditional financing route of a company, basically. But only thing that is being judged right now at the very early stage is the potential of the IP that has been created by the founders. That is one way. Okay, then another way is sometimes investors have a bunch of their own companies. Okay, because investors invest in, they have huge portfolios, 200, 300, 400 companies. They figure out at times, okay, this company's IP can be licensed to their portfolio of companies, which can in return generate enough cash flow for them to generate business. So we also structured one such agreements as well, where investors put in money and they also allowed these companies to license it to their some of their portfolio companies, creating a very well self-serving ecosystem, which is very much required in the beginning years of a company. So with these structures created, the startup was able to stand on its feet, and they were able to deliver, and then they could go out and secure more market and more players. So basically, IPs in the tech level or the startup levels can be used creatively to negotiate your deals with the investors. What startups or founders don't do is leverage too much on their IP. They simply go, they talk about go-to-market strategy and all that, which is fine. But if you're a deep tech company focused on developing tech for the next level or for the next, coming 10 years, for example, then you need to bring out creative methods of engaging with investors based solely on your IP. Okay, and this creativity is not bound by the law. Law doesn't stop you from using IP to in any which way to raise capital. You just need to be creative how to use your assets to create a certain cash flow. Okay, and again, securitization on startups, how we worked, as I already told you. You make I give you one example. We are creating one very strong IP agreement, I would say. Let me show you if we have included it. I think this is the, yeah. So what we are doing is, say for example, you have a university or some organization or your company has an IP. Okay, you're not a startup. Let's say you're an established company, or maybe you can be a startup as well. Now this startups has an IP. Okay, this IP can be licensed by one company, which is say doing okay, but they don't have money to pay the license right now, licensing fees right now. But they know if they take this IP, they will be able to create a situation in the market where their product will become more attractive. So what happens? The IP is given to the company in return of equity. And that equity is often linked with the IP ownership as well. So basically, see, if Pooja has a company which can turn my IP into a very good product, so and Pooja doesn't have the cash right now to spend on, paying me a licensing fees and all. She says, "I'll take 2% of this in your company. It take 2% of my company, and in name of your IP, And whoever owns this 2% of the shares, these shares will ultimately be the owner of that IP. Getting it? So basically, if I have to transfer the ownership of the IP that I own through equity, so I can just simply sell the equity, and my ownership of the IP also moves to the other party. That's what it means. So this is a tradable security. Now you have turned IP into a tradable security, because you cannot sell IP assets like this. But now 2% of the company basically has put a value on the IP as well. So if the company is $100 million, your IP is now valued at $2 million basically. And if somebody wants, I want Pooja's IP of Pooja's company, I need to pay $2 million. I can own the IP in that company, something like this. So you can make these patent-backed securities, and you can tokenize your IP asset. Now, tokenization of IP assets is happening in a strong way in Web3, in NFT, non-fungible tokens. Non-fungible tokens are whose values, who are themselves not fungible, not financial. Like fungible tokens are which will be destroyed as we come along. Like Bitcoin, it has a limited circulation. Ethereum, it has limited circulation. But NFT doesn't have so-called limited circulation. You just burn a token on a blockchain. You convert your real-world asset into a NFT, in a non-fungible token, in a Web3 asset. But I tell you, in a comparative world, how a Web3 non-fungible token has to be looked at. For example, I buy Mona Lisa. Okay, I have a receipt which is an evidence of me buying a Mona Lisa. Okay, Mona Lisa might still be placed at the museum, but now I have the ownership document of Mona Lisa. Okay, so I am owning Mona Lisa, but it's not with me. I don't possess it. I have the proof of ownership of the Mona Lisa though. See, NFTs work in a similar manner. So I have a painting, say, or I create a new art. I put it on a blockchain. I burn a token, and this token is bought over by somebody else. Okay. Now this art, it can travel anywhere in the world. But as long as this person owns that NFT, that is the proof of ownership of that art. And when the price of NFT goes up, basically you're saying the price of proof of ownership is going up. That's how non-fungible token has to be looked at in a real world scenario. So basically, again, when you have highly classical or highly expensive paintings or artworks that you cannot keep at your home, for example, or they cannot be moved, they have historical significance. So, but they can still be bought and purchased, right? So you buy such an art, for example, but you don't get the art delivered to your doorstep. What you have is a proof of ownership when you buy something like that. Okay, that proof of ownership is transferable, so somebody else can buy it from you when the price of the art, or basically the proof of ownership, goes up as well. So that's how you securitize and tokenize a lot of IP assets. It's happening very frequently now. A lot of money is being raised through NFTs and issuance of these tokens in the Web3 world, in the blockchain world. Many companies are situated out of Dubai, UAE, doing this kind of work exactly. Okay. Now, IP-based lending, I've already covered. I wanted to show one case study actually on the IP-based lending. Let me see. Yeah, this is one very popular case study in India. I'm covering India in this one. So Canara Bank versus NG Subbaraya Sethi. So Canara Bank had, so Sethi owed money to Canara Bank basically. And he assigned his trademark Inadu to the bank as a collateral. So he gave this Inadu, his trademark, as a collateral to the bank. So which means the bank can use and sell the trademark right. But Canara Bank cancelled the agreement, saying this is a non-banking activity, and RBI doesn't allow us to own such kind of asset. So the case went all the way to the court. The court said the deed is, first of all, invalid because it wasn't registered under the Trademarks Act. That is one point. Another thing is, even if the deed was registered, it is illegal because banking regulations restrict banks from certain business activities, including owning trademarks. They cannot own trademarks. They can create trademarks like of their own banking products, but they cannot own it. They cannot buy it in the market. Okay, which is why sometimes, so this case law uh, proves why IP-based financing remains a problem in many parts of the world. In Malaysia, there was a specially one Malaysia fund was initiated where money was parked. Some part of that fund was parked only to give debt against IP, but it also didn't work out because there was no method of figuring out IP-based valuation of the IP in Malaysian market because the market was not mature for that kind of activity. Similarly, I also feel that IP-based lending market is not that mature when it comes to banks in India. But IP-based lending can definitely work between two private entities. Okay, even in fact, when they have competing businesses, that's when it can work. So there are several regulations where using IP as collateral, especially in India, are there, where sometimes it restricts, sometimes it doesn't restrict, but most of the time it lies in the gray area. Okay, for example, Companies Act. So if you every company can acquire an IP. I can buy an IP, I can loan my IP, I can create a charge against my company. Okay. One very interesting thing about accounting in IP is when you create a patent or trademark on your own, you are not allowed to show it on your balance sheet as an asset. Okay. But when you loan it, you can show it as a charge on your company. When you acquire an IP from outside party or a trademark patent, whenever you buy something, you can show it on your balance sheet as an asset. So these are some of the problems again. Okay, then you have banking regulations. So it has permitted banks to lend or advance money without security, including IP assets. Some regulations have been improved, but they are very tightly controlled. Not many banks actually implement them right now. Okay. Then there's FEMA, SURFACE Act, allows secure creditors to enforce security interests through mortgage or assignment. So if you have defaulted on your loans or on your assets can be taken and sold over under SURFACE Act as well to recover the money, which is what happened in the case of Kingfisher. The money could not be recovered. Now, an interesting scenario came up. So the loan that was given out was, say, around, I think, $150 million. But when SBI-led consortium wanted to recover that money, the value of the trademark had nosedived because of the founder, the billionaire businessman involved in the business, and his own reputation. So they could not really recover any money out of the sale of that asset. Okay, so the IP is valued, and that actually put a break on the entire IP as lending collateral. That was a major disruption in, I would say, anti-disruption in the market, that a very valued brand lost all its value suddenly. Okay. Then IP related acts also allow you to create security interest in patents through assignment, mortgage, or license. Trademarks also allow collateral. Trademarks can be used as collateral between two private parties, definitely. Okay. Copyright Act, as I already told you, you can create Bowie bonds, these kind of situations very easily in the copyright matters, where there's a future royalty. Even if you are a popular artist, if you know your number of views on YouTube are going to increase, for example, we can do one case study. For example, the young artist comes to you, right? And you know this guy is a very good singer, very good. He can run a YouTube channel. But to run a very good YouTube channel, he needs 10 lakh rupees, for example, or 1 million rupees or $1 million, for example. But he doesn't have it. And you yourself personally don't want to be a YouTuber. You don't have the talent. So what do? You enter an agreement. You tell him, okay, I'll give you $1 million. For next 10 years, whatever you earn from YouTube, right, you give me back in so and so percentage. So he is able, this person's talent, you're betting upon based on his future earning through YouTube videos or through music streaming, whatever he creates under your agreement, basically. So whenever, say, he earns 100 rupees from YouTube, 20 rupees comes to you. So this is how IP financing and copyright can really creatively work. And similarly, it can also work in the designs as well, where fashion designers can use it and they continue to use it. Actually, it's very popular in fashion world to license your colors, your fashion, your designs, your garment style, your labels, and create cash flow opportunities in the present based on your future earning potential. Okay, I think a bit complicated topic. I will now like to open the floor for conversation so that it can be sorted in a much more comprehensive way.
Thank you, Rahul. It was indeed a complicated topic, and there are so many aspects to it. Not just the framework, but also the regulation that comes into the picture. And typically in India, since the the awareness of using IP for financing is still rising. In fact, I would say that it's still low across the globe. Even in US, it's not that very common using it as a collateral.
Hmm.
So I would open up the floor for questions, but I have a question of my own, and I
Sure.
want to, just have your thought on it. So if there
Hmm.
was a mechanism that was to be worked out in India for using IP as a collateral by the banks, there are a number of changes that need to be bring in. But what are
Hmm.
the changes required at the IP regulation
Hmm.
as well to
Hmm.
be, in a position to combine both?
Okay, see, what mostly happens in IP regulation is when an IP is assigned in India, let's talk about India. Okay, when an IP is assigned in India, what they do is they pay a stamp duty. What they do is they show IP assignment of 1 rupees, and rest of the agreement is done for knowledge, know-how, right? And the entire value is basically skipped out of this deed of assignment on which actually the stamp duty is to be paid, right? And the rest of the agreement is done on that way. So there's a loss of value already created. So that should not be allowed, I would say. There should be strict, like if you have an underlying agreement, make sure, say, an entire company is being bought over, say for 100 crores. Okay. But if they say, okay, for 20 crores is the IP, then they should pay a stamp duty worth of that. That will create a value or at least a benchmark. Last time this was sold for 20 CR, right? And now this was the kind of stamp duty that was to be paid. That will build real FOMO, I would say, or a real value around IP as well. But now what they do is, if companies 100 CR, they don't want to pay a stamp duty extra on IP because IP stamp duty may be higher or whatever. They show it, okay, we took the IP for say 5 lakh rupees. You know, everything as so the value has been pushed into the real assets. So that should be discouraged, I would say. Real value of IP should be analyzed. Another could be changing in the accounting principles, which could happen, but it is not really at the IP level. It is at the corporate law level, I would say. Accounting related standards need to be improved, but at IP rules and regulations, I would say more attention should be given to the deed of assignment and the stamp duties that are being paid with respect to the assignment or licensing. They should reflect the true value. Then only you can go to the court or go to a bank and say, hey, I bought this for 20 crores. Okay, there's a legitimate document. Okay, we agree as we go along. The IP, say patents, 5 years down the line, patent is good only for 10 years, right? But then you also have captured the market. So how do you arrive at the right value? That is a debate to happen later. But at least when you go to bank, you can show, hey, we bought this for 20 crores, right? And because we bought it for 20 crores, we have a market cap of so much. There has to be some interlinkage. Only then you can create it. But when banks look, when we as a company, when as a law firm, when we do due diligence and we look at the deed of assignment, 1 rupees against 1 rupee or 100 rupees, and they will put 100 rupees stamp paper and do the deed of assignment and transfer the IP rights. We say, okay, there's no real value they're capturing themselves in the legal documents. That is one problem, I would say.
Thanks, Rahul. It's really useful to know there are a number of changes that could be done. And as an IP professional, there are changes that we could help with. So
Yeah.
now I'll open the floor to everybody to ask their questions. They can unmute themselves and ask the question. So everyone, you can unmute yourself and ask your question directly to Rahul. We can have a conversation on it. So while some Gauri, would you like to go ahead? You have a couple of questions.
Yeah, yes, ma'am. Hello.
Yeah.
Hi, Rahul. Actually, I have
Hi.
few questions. So I have listed in the chat box, like,
Oh, okay.
so is it similar to debentures? So they are raising money without diluting the shares. It means is they are similar to debentures?
No, see, debentures, you can create both kind of opportunities, I would say, in that. But when you see, debentures is when you pledge the security of a company, the equity of the company, the share. Okay. When you pledge the IP of the company, you're not really creating a debenture, you're mortgaging an asset. But you can link both. You know, you can say, okay, we are giving you IP. If this IP, if we are not able to pay you the loan back, we'll give you 3% equity in the company. So that's how you're able to license. You can be creative with this kind of opportunity. So what does the lender, me as a lender, I say, okay, what if you're not able to generate money for me, you're not able to service the loan for me, right? And I give you a very practical situation. For example, you start a company, you raise $1 million, say 10 crores, for example, you raise 10 crore rupees, and and before that you have raised 2 crores by mortgaging your IP to some investor, some other guy. Now, when you raise this next round of money, 10 crores, no investor will agree to service an existing loan. They might not agree. Okay.
Yeah.
They might say, okay, do not service the loan, use this in the growth capital, right? Now, me as
Yeah.
a founder who had promised, in the next fundraise, I will start paying you back. I'm not able to pay you back. So what me as a lawyer, what I can suggest, hey, if he's not able to pay back because of restrictions on him as a founder, you give him equity
Okay.
and convert this loan into equity. So you can link all this together. And all this can be converted and linked via proper contracting. So what I'm saying is, in India, in very often in my firm also, we keep asking our colleagues, come up with new methods of new instruments of raising money. And unfortunately, only being used is CCPS or CCD or convertible note. They seldom use IP. We are right now, I'm working with some universities where we are actually figuring out how to make their IP, because they cannot hold equity in a company, universities in India. Okay, so how? But then IIT Madras has a lot of professors holding equity, right? IIT Madras is the applicant. Now, this
Yes.
is a very, any IIT, not IIT Madras, any IIT or any public institution. Now, what is happening in India, if you look at it, if there's an inquiry, you will find it very problematic. There's an IP angle when a student and teacher startup comes into picture. Okay. Now, this IP is owned by this government university XYZ. Okay. But the equity is taken by the professor. Okay.
Yes.
And the students. And then a licensing is worked out with the university at a very nominal fees. So public institutions never really get to enjoy the huge growth that happens in these kind of tech companies, because the fees is very nominal. So we are working out an instrument right now with putting our brains to it. What could we do that this university is able to own the IP in some manner, right?
Okay.
Or own the equity in the company in some manner. Is it through debentures? We don't think so. What could it be? We don't know. We're figuring it out. But the thing is,
Okay.
no law in India prohibits you from being creative around creating opportunities in this scenario. If a startup has an IP, there's a private investor willing to give money against, say, 2 crores, pay me 10 lakh per year for next 5 years, and 2 crores after that, you pay me back, fine. But what if they are not able to do, what then? That is the question this investor wants to ask or wants answered. You can say, okay, if it doesn't happen after 5 years, we give you equity worth so much, right? And that's how you link it all up. So you can be creative around it. So there is no debenture that has gone out. So you have not really valued the company. So you have escaped the company valuation compliance altogether. You only valued IP. You took loan against the IP.
And
There are
what
no.
are the
Yeah.
fluctuation after, like, sorry to interrupt, but what are the fluctuation after, suppose currency appreciate or depreciate? So in that case, how we can
See, all this can
protect
be
the graph?
discovered. All this can be negotiated in the agreement.
Okay.
Again, being creative. See, if the money
Yeah.
has come out in $1 million way, right? And the currency has appreciated and all. So you want to say, I want return on the dollar, not on INR. You know,
Okay.
okay. So you want return on the dollar. And
Yes.
when you convert me after 5 years into certain equity at your cost, at your value, at your tax, then you also convert me according to the dollar. So you
Yes.
talk only in dollars then. So agreements
Okay.
can be made in a very creative manner in that way.
Yeah. There are a lot
Okay.
of things actually.
There are a lot of
Need
things.
to
Yes. When you sit
for
down,
this.
that's why IP and corporate law are very interesting frontiers to explore. And it's unfortunate that in India, not much creative work is being done by even the AIFs, alternative investment funds. They don't do it. They're betting it all on, they want IP, but they don't value IP. It's like that.
So I have another question. If
Sure, sure.
somebody is interested, then I will stop. Is any other person is
No,
there?
continue.
Why do you continue and then we'll request
Yeah,
others
Rahul, I
also.
have another
Yeah,
question, which is
yeah.
related to non-fungible tokens. You told me that it is
Sure, yeah.
similar to similar to cryptocurrency. So it's somewhat look like a hot money, or its bubble can be burst anytime. So how we can how it is regulated then?
See, in India, it is not really regulated. Only regulation in India that has come up is the capital gains, 30%. So the regulation, what happened to that is now all the companies have escaped, basically. So no company exists in India anymore. Most of the blockchain coders are from India and they don't operate their businesses out of India. Okay. Dubai has come up, UAE especially, and Dubai in particular, has come up with a VARA, Virtual Asset Regulatory Authority. So under that is also very caged regime, but at least there is a predictability in when you have a regulatory authority. Similarly, Malaysia has also come up with a very similar, Malaysia and Singapore, very similar, where if you want to release tokens or if you on an exchange, you have to follow certain regulatory authorities. So different countries have come up with their own paradigms. US has still not come out with anything. It still is used under securities law of India, US. In India, it is being regulated via regulations or guidelines issued by RBI, basically KYC and all that. But because of the humongous capital gains that is enforced almost immediately, 30%. So many the developers and companies have started doing business from UAE and Singapore, these kind of places. Even a lot of Indians are involved in that. Okay. So, so basically, you then go and work in countries either where there is no regulation or where there is a certain regulation if you want to raise money. So most of the Web3 companies are structured in Cayman Islands or BVI, but when they want to raise money, they come to UAE because UAE offers Virtual Asset Regulatory Authority, which makes sure no investor is, shortchanged because of investment into a certain Web3 company. And all these investments also happen in these companies via tokens, never in hard cash. So if you hear a news that this Web3 company or this crypto company raised $5 million, it's not in hard cash. It's 5 million in the crypto world. That's how. Okay. So it's not like they raised money in the company itself. So how do you structure something like this? So they buy your currency online and then take equity in your company. So your currency is valued at 5 million, but your company's equities are subscribed through nominal price. So that is another challenge, or you can say angle, that is now being thrown up regularly to the regulators. How do you bring both of them together? Right? If company has 10,000 shares, right, and they have issued 1 million currency notes, should they be linked to each other? Should they not be? If they're linked to each other, it defeats the purpose. If they're not linked, then how do you value the company and currencies separately? Many financial challenges as well, not just legal as well. Yeah.
I have another question as well.
Sure.
Regarding SURFACE Act. So, as we know that in case of SURFACE, there are some timelines for enforcement of securities, and is the same timelines are applicable to IP as well?
That I have to check on it. On this, I have to check. Really, yes. I'm not practiced in SurfAC. But I can check on it.
Yeah,
Let
because
me.
after 3 months
Hmm,
timeline they are
hmm. उनका
issuing the
तो 3 months
notice
है, उसमें तो
and
3 months है कि if you
yeah.
default 3 months, it goes under SurfAC. That is very much there. On IP, I think also
Yes.
should be the same, but I can check on it.
Okay, okay, okay.
Yeah, yeah.
And also in the same way, the mm, other things happen after he's not able to pay back the things.
Yeah, same. You pull out a notice. You call the interested parties who can come down, look at it, just like it happened in case of Kingfisher, but never really got sold because the
Okay.
price nobody even bid 150 crores. So SBI canceled the bidding. Yeah,
Yeah. Thank you, Rahul. I think someone having
yeah,
questions. So
yeah.
Yes,
Hi,
Gauri will.
hi, sir. It's a
Hi.
very enlightened session. But anyhow, I just have a very basic questions. First question, you told about that
Hmm,
regarding marching and collaboration. There's a they will see the health of IP. So it's a how
yeah.
healthy is it
Hmm,
the healthy means the TRL level of the IP,
hmm. Not
or
really.
can you please cut
See,
or can you please brief on that,
I will tell you.
or did
I will tell you.
yeah, yeah.
See, TRL level is with respect to the product or prototype.
Yeah.
It has nothing
Yes.
to do with the strength of the patent itself. Okay. The strength of the patent, I give you one very good example. It's a very popular company in India. They came to us after they had already filed first patent. The product was doing well. Now, this company had filed a patent on a robot. Okay. Now, the patent on robot was written like this: a robot comprising a head, torso, two legs, two arms. Arms has camera. Arms has another five elements which will go inside a certain pipe and do some work. Okay. This was their claim one. Product went on very well. It was being supplied across the world. And then somebody from a government university took the hand of this robot, attached it to a simple Maruti 800. Okay, made some robotic changes to levers, and added some levers and all that to Maruti 800, and did the same activity of the hand. Okay, in those pipes. That's it. And the client then came to us saying, "Hey, these guys have infringed my patent," but they did not, because they claimed a robot having head, torso, and everything, right? But what the competition did, they took one part of it, modified it slightly, and started using it. So the patent was weak. So when we do due diligence, we look at patent from these kind of perspectives. Is the claim good enough? See, in robots, all part are robotics. Legs are also robotic; they can move. Hands are also robotic. Head is also robotic. Everything is robotic. So robot is some total of robots, basically. All coming together and performing function in sync, in synchronization, right? So when you write a patent application, have you considered this aspect at all or not? So when we judge an IP's strength, we judge it on the basis of the claims. Number one, are the claims covering the product and its several embodiments or not? Number one. Number two, is the ownership firmly with the company or not? Sometimes you are working in a university, you file patent in your name, you started a company, and a university comes to know after 5 years and they lay claim this was under employment agreement. Its IP was to be with us, but this guy, they didn't inform, and now they have made a company. And under the law, they will be right. You will have to share the ownership or some royalties with them, right? So when we do IP due diligence, we want to make sure the ownership lies with you formally, properly, through proper agreements, contracts, NOCs, whatever. If not, then we demand that these compliances be done, these discussions be done with the university. It is like buying a land. When you want to buy a house, what
Okay.
do you do first thing? First thing you do is make sure the ownership is with the person you're buying it from, right?
Correct.
You
Yeah.
do a due diligence on ownership. That's one.
Sure.
That's the second. And the third level of due diligence is definitely whether there's a litigation against the patent, whether there's an opposition against it, etc., etc.
So it is basically claim bound like that. I can just
Claim
understood
bound,
that
yes. Starts
claim
from the
down.
claim bound, but then
Uh,
goes on to
ha- what is the what is the what is the years spending for this live of the patent, and as well as any litigation against it is there or not? The three things.
Yes.
Thank you. Thank you.
Yeah.
Another one point, just
Hmm.
I have wrote it here I just in the chat I think it has gone. So in that
You have mentioned to give details
yeah,
on collateral agreement.
yeah. Can you please
Come again.
collateral agreement, can you please
Hmm.
brief on that, just brief on that? Well, like
See,
some agree
collateral.
yeah.
What is the specific question on collateral agreement? Okay, you say, can you please? Okay, this is basically a lending agreement. Collateral. See, in IP, unlike real asset, IP is a fluid asset, I would say. So this is intangible, can be used in any which way, can be used in a much more creative manner than a real asset. Okay, so collateral agreements, when you use IP as a collateral, okay, are you when you're not licensing it, number one. So collateral agreement should make very clear that you're not licensing the IP to the party who's loaning you the money. Being collateral is very different from licensing. Licensing gives the right to other person to use the trademark or use the IP. Okay, collateral doesn't give that
Okay.
right. Collateral agreement should make sure this is not an assignment, this is not a license. Okay, you're holding this asset, okay, against the money that you're given us, but you have no right to use it. Collateral
Okay.
agreement also mention that if there is an infringement proceedings, or if there is a revocation proceeding, or that this IP is invalid, then the person who has given you the loan is suitably rewarded, or the damages be paid to this person. Because in the collateral agreement, the very important, one of the most important part is the warranty and representation. So as an IP owner, I'm warranting it, I'm representing this patent is irrevocable, this patent is good, this cannot be invalidated. If it is invalidated, I will pay back so and so. So this becomes another due diligence on the part of the person who is who's raising the money through loans, or the IP owner. So the collateral agreement is a very creative agreement in that sense, because you're restricting uh, uh, IP in a very different way. It's not licensing, it's not assignment, it's not exclusive or non-exclusive license. It's nothing. It's just store. You're giving IP a temporary possession of the IP to this person. That's it. Okay.
Thank
And
you.
the agreement must make sure if the loan is defaulted, this owner has to assign the IP to this lender, so that he can reflect the same in the records of the trademark or patent registry. Because every licensing agreement, every assignment has to be recorded at the proper office for it to take effect. If it is not done, then that licensing has not happened. Agreement is void. Okay, so that's why collateral agreements have to be a bit more creative in that way.
Creative, yeah. Thank you. Thank you for that. And can we have, or I'll ask Pooja, ma'am, can you share your PPT? It is very like knowledgeable session. It will be helpful for us if you share, if possible.
The presentation and the recording will be available on the Dhwani channel. So I'll be sharing that link after this meeting.
Yeah. Thank you. Thank you for this session.
Thanks a lot. So if we have no other questions, maybe we could end the session, because Rahul has specially given me an hour. He is on vacation and he's given me an hour. So any other questions, I could email to him and he could respond back on it. And I would like to thank Rahul and everyone to join and discuss about IP financing and how we as IP professionals can bring in a change and help build startups and innovators more effective IP portfolio. So thanks a lot. And see you all again for the next session, which is on 15th, where an entrepreneur talks about the experience of raising funds using IP. So I hope to see you all there. Thank you very much.
Thank you, Pooja. Thank you, everybody. Thank you.
Thank you.
Feel
Thank
free
you.
to shoot questions, and I will get my team or myself to answer those as well with proper research. Okay. Thank you.
Thank you.
All right.
Thank you.
Bye. 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 Bye.